Welcome back in here to Live Now from Fox. I'm Andy Mack. Let's turn our attention back to the case as the verdict coming down. It was guilty across the board for Ryan Routh, the man accused in the shooting or would-be assassination of the then candidate Donald Trump, as this was the kind of verdict slip. It was guilty on all of these counts, including attempted assassination of a major presidential candidate, possession of a firearm, and furtherance of a crime of violence, assaulting a federal officer, and the list goes on. But it wasn't the only major development today, as this was the court sketch inside of that courtroom in Fort Pierce, Florida, as the man who attempted to assassinate Donald Trump at a Florida golf course last year tried to stab himself in the neck with a pen shortly after being found guilty of all counts on Tuesday. Let's bring to the conversation right now legal analyst, friend of the program, Jeremy Rosenthal. Jeremy, thank you so much for joining us here on Live Now from Fox. And of course, this verdict might not have been surprising. The impact the event immediately after was. What's our big takeaway today?
Look, anytime you have a really bizarre trial like this, I don't think it's a big surprise to anybody ultimately what happened. This was a layup for the government. If you're a federal prosecutor, if you're a U.S. attorney, you kind of don't want to have this case, because all you can really do is screw it up. And in this instance, obviously, they got their guilty verdict. It was a very easy one for them. You had a pro se, meaning a man on the other side who represented himself. And if there's an issue going forward, it's going to be, should he have been allowed to represent himself? Trying a case is a really hard thing. Having a jury trial is a very hard thing. Imagine trying to teach a college level course, and every time you take a break, there's somebody who comes in, a professor who comes in and tells the class and teaches the class why everything you just said is wrong. And then you do that for 2 or 3 weeks. It's very hard, very difficult, very intricate to try to defend a case like this. And to do it on your own, you're simply never going to be successful on it. Maybe a traffic ticket at best. Other than that, again, I don't think the verdict was surprising one bit, and we'll see if he's able to have any headway on appeal. There's probably an issue there, but no shock from where I think anybody's standing.
Yeah, and of course, the kind of government, the prosecution rested their case the end of last week. He got the case this week, and then deliberations took just a short amount of time. There was standby counsel on hand, and usually when we're talking about people and defendants, they're not asked, not told to take the stand. Obviously, they have that right, but it was somewhat interesting that he was representing himself, and then he also didn't take the stand. Did that catch you by surprise at all?
That's a pretty interesting point, because if you're Ryan Routh, how else are you going to try to win this case, right? How else are you going to try to show the jury that there's a reasonable doubt? Not that the burden shifts to him, but usually, typically, if you are of the mindset that you're going to make this stage all about you, you're going to get up and you're going to testify. In this instance, what the government has to prove, or what they had to prove here, was that there was an attempt to take the life of a major presidential candidate. And when you're looking at an attempt crime, what you're looking for is a plan plus one overt or a substantial act or step towards that goal, right? If you're talking about robbing a bank and then you actually go out and arrange for a getaway car, that would be an instance. And in this instance, he had written a note that he was going to do this. He was there waiting for 10 hours. He had a rifle. The DNA matched. And when all of these things are presented, look, the burden doesn't shift to him to prove your innocence, but if you're going to get out of this, you gotta tell your story why. And if you're representing yourself, you're really not going to be very good at presenting other evidence. You're not going to be good at cross-examining other witnesses. What are you going to be good at all, really? You might be able to tell your story at most, and then he didn't do that. So, yeah, kind of a surprise there.
Yeah, and I don't know, based on some of the previous motions that he put forward, the questions during jury selection, that it would have been somewhat entertaining or comical, just peculiar to see what he would have said on the stand, but I don't know if it moved the needle at all in terms of the jury. Let's talk about this major moment, though, that happened immediately after the verdict came down, in which he grabbed a pen and then tried to stab himself in the neck. The officers quickly swarmed him, dragged him out of the courtroom, and obviously this is what the sketch is showing there of this moment. And we know that standby counsel was on hand. What do we make of this? Is there going to be extra security around Ryan Routh moving forward? Is that something the judge levies to make sure that he's not trying to kill himself again, potentially?
He would almost certainly be on some kind of suicide watch, and that's typical after a guilty verdict anyway. But I don't think there's any reason that they're going to allow him to be around anything like that. He still has sentencing to go. There's going to be a pre-sentencing investigation, and sentencing is going to be on December the 18th. This may trigger Judge Cannon to disallow him from representing himself this action. You have a right to represent yourself in a criminal case. That right's not absolute, and the judge can revoke that if it's sort of just overly disruptive to the proceedings. And if they can't put him in a room where he can be trusted with a pen or a pencil or something like that, then I don't see how they could really, how the judge could really trust him to try the case or to finish off the case. Because the pretrial, the sentencing in this case is a really, really big part of the case that is not yet done. And in a lot of federal criminal cases, that's really, frankly, the biggest issue and the only issue that you're trying the case over. Most of these cases in the federal system are slam dunks just like this. And the sentencing is again, a really major component. And if he is of this mindset, and if you can't trust him to be around other people like this, then I think that's a pretty big problem, because he will have to meet with federal probation officers. He will have to do some additional work to prepare his defense for sentencing. That part's not yet done, so I don't know that the judge is going to let him continue as his own lawyer.
I want to ask you, because we see this moment happening. Even his kids in there were kind of crying out, saying, "Dad, don't do this in this way." In terms of the appeal process, does the fact that this happened make the judge go back and say, "Hey, maybe I should have stepped in, so we should have made counsel be there for him prior"? Does this change anything in terms of the appeal process and having the fact that he represented himself and potentially mental issues, that's the like? Do you think that could help his case in the appeals?
I think, unfortunately, Andy, I think you're exactly right. The big issue that he has going for him now, frankly, the only issue he's got going for him is what is called a Ferretta motion. When you ask to defend yourself in federal court, the court does what's called a Ferretta analysis. You have a Sixth Amendment right to be your own lawyer. And when you do that, the judge has to make sure that you understand everything that's going on, and that you understand that you're responsible for behaving like a lawyer. You're responsible for all the objections. You don't get any special preferential treatment over the other party in the case, and that you are responsible for your legal defense and everything that entails. Functionally, the equivalent of performing surgery. In this instance, it would be on yourself to sort of expound it. And if you don't have the mental capacity to do that in the first place, then that can be very, very problematic. But how do we know if somebody's got the mental capacity to do this or not? That's the really hard question to answer. And if on appeal, he can establish, or his lawyers, you don't actually have a right to represent yourself on appeal. So his appeals lawyers will almost certainly argue, look, he didn't have the wherewithal to try this case. And if they're right, if they're able to win on those grounds, then he would almost certainly get a new trial. And yes, the fact that he is acting out in this manner will almost certainly be pointed to by his appeals lawyer, saying, look, this guy never had the marbles to defend himself in the first place. It's one thing to somebody wants to make their own political statement. It's something if somebody wants to kind of turn the court into their own showroom. If they understand what's going on, unfortunately, they're allowed to do that. But then again, you have people, if you've got a criminal defendant who wants to talk about his banana boat and his banana phone and his banana car and is just out of their mind, then that person probably has no business representing themselves, and the judge probably should not have granted that Ferretta motion. That will almost certainly be the grounds for his appeal.
Yeah, we'll see what happens there. And you mentioned the fact that if this moves forward, obviously the appeals process will play out, but the sentencing could be important in certain dynamics. Can you get into that? Explain that for us.
The federal sentencing guidelines are what dictates here, and it's essentially a grid or a matrix, and it's literally a graph with an x-axis and a y-axis, and the x-axis is going to be your criminal history. Have you ever been in trouble before? The answer with Mr. Routh is yes. He is a convicted felon, and he was convicted of some dangerous felonies too, I believe, with explosives. And the other axis is the severity of the crime that you've been convicted of here, which again is going to qualify very, very highly because this carries up to a life sentence, the attempted assassination of a major political candidate. So what's going to happen is when you put him on the grid and you put him on the matrix, he's going to wind up on the very far right-hand side and the very lower portion, which is not where you want to be. Meaning that Judge Cannon would almost certainly be able to put him in prison, if not for life, pretty close.
All right, we'll see what happens there. And I just had another question, kind of circling back one more time to this incident, this acting out in courtroom, because we did see his kids there, and we did get video of them. They weren't talking to the media or whatnot. Is there anything potentially they can do to step in to say, hey, maybe this individual should have a lawyer present? Is there something that they can do to kind of step in since they are family, since they are related to this individual?
I think tragically for Mr. Routh, I think the damage is done. When you have your trial, that's your day in court. And in this instance, if he's got a screw loose, if there's that lack of mental capacity, the time to complain about it was a month, 2 months, 3 months ago, 6 months ago. Going forward, he will have the right to appeal. Now, when you represent yourself, that's one of the big problems. It's one of the major reasons that you don't really do that, is because again, kind of going back to the beginning of our discussion, if you're the U.S. attorney, if you're the federal prosecutor, all you stand to gain is potentially screwing it up. You are expected to win this case, and you're expected to win it big, not only because the evidence in this case is overwhelming, but because you've got a person on the other side who doesn't know any of the rules and who, if you do make a mistake, isn't going to be prepared to catch you in that mistake, which is a major part of trial advocacy and trial law. So a lot of the issue, if the government did make mistakes, if they made missteps and if they made errors here, they all went unchecked. Those errors are what are called waived because the defendant either didn't object or he didn't object properly. But again, going back to that singular issue, which is really out of the prosecution's control, it is whether the judge should have allowed him to represent himself. And it's quite possible she made the exact right call, because just because he is not completely off his rocker doesn't mean that she's wrong. If he understood and appreciated all of the rights that he was waiving by representing himself, then she made the right call, because legally he does have the constitutional right to defend himself.
All right, very good. Jeremy, thank you so much explaining there. Obviously very understanding, but the verdict coming down all guilty across the board for Ryan Routh. Thank you again. I appreciate your time, as always, here on Live Now.
Have a great day.